Hi folks, and welcome back to Innovation and IP Law. This is video 2 in the video series on commercialisation. And if we jump back into our Prezi, you will recall that in video 1 we had an overview and we also looked at the aims and objectives of the IP due diligence process, which are a little different depending on whether you are the investor or the target company. And we also had a little look at identification. And now we need to look at probably what's the most common problem uncovered by IP due diligences, and that is problems to do with ownership. So we'll jump in and have a look at ownership now. Why are ownership issues so important? Well, obvious really, isn't it? If you think back to your contract law unit, and we all learned that lovely legal Latin saying, nemo dat quod non habet, which is you can't give what you don't have. Fairly fundamental to an IP transaction. If you're going to purport to contribute some intellectual property rights to technology or a creation, then you need to actually own the technology or creation and the IP rights therein. Otherwise, the deal is going to go pear-shaped quite quickly. So when you're looking at this particular potential fly in the ointment, you need to bear in mind 3 different issues. Firstly, the default arrangements for ownership under the various different IP regimes, the statutory regimes, and also you need to think about employees, and that's where a lot of the flies in the ointment tend to congregate. Other parties, third parties, can also pose an issue, and here I'm particularly thinking of consultants and directors. So we'll look at each of these 3 aspects of ownership in turn. So first, looking at the default ownership position under the statutory regimes, the first creator or inventor is going to own their creation or invention. I've just listed the various different sections of the statutory regimes there. No real magic to it. Fairly commonsensical arrangement, if you ask me. For trademarks, the text seems to overlook trademarks a bit, but certainly the registered owner is treated the same. If you have a look at section 20, the first registered owner will be the one to own all the exclusive rights in the trademark. So that's the default ownership position. Fairly simple, like I said. Then we get to employees. And when you're thinking about employees and ownership entitlements to IP rights, the first thing that you really need to do is work out whether, in fact, the person that is raising a claim or could potentially raise a claim to the IP rights in the invention or creation or information, whatever it is that's the subject of your investigation, you need to work out whether they actually are an employee or whether they might be treated as a third-party consultant, contractor, and so on, someone at arm's length to the actual purported owner, in which case they will be treated very differently. So in embarking on your first step here, you should be familiar, for those of you that have done tort law, with the case of Hollis and Vabu, a case of the High Court, a rather entertaining case about what can go wrong when you are a courier delivery person. Poor old Mr. Hollis worked for Team Couriers, the white hats innocent party in this particular case, and Mr. Vabu ran a bicycle courier company full of rather errant bicycle delivery people by the name of Crisis Couriers. Mr. Hollis had collected some parcels and had stepped out onto the pavement a couple of steps, and you guessed it, one of the Crisis Courier bicyclists came crashing along the pavement and into Mr. Hollis. He sustained rather serious injuries to his knee, in fact, around about $180,000 worth of injuries to his knee. And the question here was whether or not the courier person, the crisis courier person working for Mr. Babu, was in fact an employee or an independent contractor. If the errant bicycle courier rider was employed by Mr. Babu, then obviously Mr. Babu was going to be vicariously liable for that bicyclist's negligence and therefore would have to foot Mr. Hollis's bill for his knee. In that case, the High Court rather helpfully set out a stack of factors that would point to an employment scenario rather than an independent contractor scenario. The court below had thought that the bicyclist working for Crisis Couriers might have been an independent contractor because he had purchased his own bike and was riding his own bike, buying his own accessories and so forth. And the High Court said, no, well, not really. When you look at the overall circumstances of the relationship between Mr. Babu's Crisis Courier company and the riders that were engaged therein, it really did suggest an employment situation rather than independent contracting. Things that pointed to the employer-employee relationship. The employer could exercise control over the way that the couriers did their work. The work was obviously integral to the employer's business. And there were various factors around the way that these couriers were paid their remuneration that certainly suggested an employment situation. So the mode of payment, provision of certain equipment, hours that were stipulated, provision for holidays, that's a big one, deduction of income tax and delegation of work. So I would encourage you, if it's been a little while since you've had a look at the Hollis and Babu factors, I've linked it in the study guide. Go ahead and have a look at Hollis and Babu. It's a good case to keep in mind when you are thinking about IP ownership rights and whether or not a person that has contributed to the creation of an invention or a work or a subject matter other than work might be an employee or might not be an employee. The position of employees are treated differently depending on the type of IP right that you are considering the ownership question of. So firstly, let's have a look at patents. Now, while the Act doesn't expressly state the word employees, nevertheless, Section 15(1)(b) does deal with and is generally acknowledged to indicate the position regarding ownership of employees. And Section 15 deals with the people that a patent can be granted to. And 1(b) states that a patent can be granted to a person who would be entitled to have the patent assigned to them. Would be entitled to have the patent assigned to them. And generally speaking, an employer at common law, where they've paid an employee to do something, and that results in an invention that's patentable, they will be subject to an implied term in their employment agreement to assign the benefit of the invention to their employer, or sometimes they hold the invention on trust for their employer. So 15(1)(b) is the provision there. It sweeps in, as you can see, would be entitled to have the patent assigned. What entitlement do they mean? What entitlement are they talking about? Relies on the common law principles that have been developed over the years in terms of both master and servant and equitable notions of fidelity and good faith and fiduciary duties. And probably the best case to look at in terms of employee rights in relation to patents is the Electrolux and Hudson case. Another delightful case that you should be familiar with for the purposes of this course. And it's a decision by Mr. Justice Whitford in the English High Court with the Chancery Division, reported in about 1977, late 70s. And you know it's going to be a good case to read when it starts off with the line that Mr. Hudson and his wife were inventive people. And Mr. Justice goes on to describe a rather cosy scene where the husband and wife would routinely get together in the evening and discuss ways that they could improve the world via their inventions. And it talks about one of Mr. Hudson's inventions being some kind of television process that would allow trains to see further along the track for safety issues. Mrs. Hudson had come up with an idea for an invention that would allow you to work out how long a traffic light would take before it turned from green into the more dangerous and risky orange or red. So they used to have some interesting dinner table conversations in the evenings, Mr. and Mrs. Hudson, and one evening they had turned their collective inventive minds to the problem of vacuum cleaners and having to constantly replace the filter bag for vacuum cleaners. So in the days before the Dyson cyclonic technology for vacuums that really did revolutionise that particular industry, where you don't have to have a bag anymore because, you know, the dust just gets sucked up into the vacuum and it whirls around in the barrel, the collection barrel, and then you just empty the barrel. In the old days, as you can see, I've got on the slides there for those who haven't seen these before, the old vacuum cleaners used to have where the pipe connected into the body of the vacuum, you'd have to put in a bag, and I've got a photo of the bag there, and you would have to actually dispose of all of the bag and the dusty contents, and then buy a spare part bag and pop it in and keep on with the vacuum cleaning. These bags were kind of special because they allowed the vacuum to fill the bag with air. The air would escape, but the dust would still get caught. And Mr. and Mrs. Hudson thought, there must be some better way. Wouldn't it be good if people didn't have to buy these spare part bags anymore? Wouldn't it be great if we could just have some kind of universal adapter that would allow you to pop any old bag on there and you know, carry on your way with your vacuum cleaning? And of course, the Electrolux company wasn't terribly happy about this particular invention, particularly given that Mr. Hudson worked for Electrolux as a salesperson. So the case revolved around the tussle between Electrolux and the Hudsons. And Electrolux obviously wanted to get their hands on the rights here because they basically just wanted to shut the whole thing down. They didn't want this invention going on the market and undercutting their revenue for spare part bags. So it was a rather interesting case on a number of fronts because Mr. Hudson had a contractual restraint in his employment contract, and it was a very long and convoluted restraint clause. I won't bother reading it out to you, but do go ahead and have a look at it. I've linked the case for you. As I said, it's a rather delightful case to read. The problem with the specific contractual provision there was, as you'll recall from your contract law days, any contractual restraint that purports to put limits on what an employee can and can't do, particularly post-employment, will be subject to fairly close scrutiny by a court, and it has to be reasonable as between the parties and reasonable in terms of the public, and any restraint that is seen to be overreaching or too broad, too unduly limiting for the employee will simply be struck down, and the court will consider it void and therefore unenforceable. That's exactly what happened here, and so Electrolux was thrown back onto its common law arguments for ownership of this particular invention. In terms of the master and servant principle, very simple. I'll talk about it in the study guide. You know, if the master, that is the employer in olden day terms, has paid the employee to do something, then generally speaking, they're going to own it. The issue for Electrolux here was that obviously the invention had occurred in the confines of Mr. and Mrs. Hudson's cosy home during a discussion after dinner. Certainly not in the course of Mr. Hudson's ordinary duties as an Electrolux salesperson. So it fell outside the scope of his usual duties and therefore wouldn't really fall within that kind of principle. There was also the issue of the equitable duties of fidelity and good faith, and certainly you can raise these as an employer against your employees during the tenure of their employment. And here, I think Electrolux fairly unsurprisingly argued, well, hang on a minute, if Mr. Hudson, who is employed by us, has come up with an invention like this, that he would know we would want to find out about. Surely he has a duty to disclose that to us. And the court said, well, yes, he might have had a duty to disclose, but then really Electrolux wouldn't have been interested in taking up any opportunity that Mr. Hudson offered them in order to take up the patent and run with it and commercialise it, because at the end of the day, they just wanted to suppress the thing. They wanted to bury it. They didn't want getting it out to market. And in the end, the court came down on the Hudson's side of things and said, look, Mr. Hudson's been very honest. Certainly the Hudsons came across as very truthful witnesses. And he told the court, really, look, all I was trying to do was make a little bit of money on the side. The court believed him. They said he had no intent to harm any interests of the company, didn't breach his duty of fidelity and good faith to the company, and therefore the Hudsons were free to go about commercialising their little invention as they saw fit. So that was Electrolux and Hudson. Just be very careful, because patents, the employee situation for patents doesn't necessarily apply to all kinds of employees. And here I am particularly thinking about academics. And I've set the University of Western Australia and Ray decision, the full federal court decision for you, 2009, to read for this week as one of the set readings. Very important decision in terms of academia and whether or not professors can retain the ownership of inventions that they create during the tenure of their appointment as an academic. Go ahead and read that. I won't talk too much about it here now. Suffice to say that academics around Australia rejoiced in the fact that Mr. Ray got to retain the rights in his invention. Exactly what arguments were successful there, I will lead you to ponder during your studies for this week. So that's patents and employees, and it's past the magical 15-odd minute mark now. So I'll leave this video here and I'll jump across to video 3. So till then, bye for now, guys.